Good afternoon, everyone, and welcome to today's session of the Wednesday morning coffee break, where we're going to be talking about name, image, and likeness, and some of the new developments that have kind of come up in those areas. This is not an area that I know anything about, so I'm actually really excited to hear about this topic and learn a little bit more about this area. I know it's kind of a brand new thing, if I recall correctly. With us today, we have Dave and Charlie, who are attorneys over here at Foster Swift and kind of some of our leading experts in the areas. I want to thank you two gentlemen for taking the time to speak with us today on this. Before we get into some of the questions that I have, can you kind of give us just a very brief rundown of name, image, and likeness, and kind of what the status of the law is and what some of the recent developments are?
Yeah, so I can do that. So name, image, and likeness, what we're referring to in the college athletics area is student athletes entering into deals, whether that's with third parties, businesses, or as we'll talk about here, schools now, um, to profit off of the use of their name, image, and likeness, right? Schools, TV networks, they've been for years have been raking in millions and millions of dollars off of college athletics. So now what we're talking about is students getting a cut of that. And it really started to gain traction back in 2021 with the Alston case that kind of opened the door to student athletes being able to profit off their NIL. Fast forward to this past Monday, where we have the House settlement, which is what we might want to go into next, Rob.
Sure. But before we get into that, and you kind of alluded to it, were these athletes not able to, kind of get into these agreements and profit off of their, the use of their name and the recording rights and all of those sorts of things? Was that prohibited beforehand?
Yeah, so I'm Dave Russell.
Yeah.
Prior to 2020, the only thing that colleges were able to offer student athletes, was the scholarships themselves.
Okay.
And so, as Charlie alluded to, the Alston case, which went all the way to the U.S. Supreme Court, it was a unanimous decision in 2021, determined that schools could provide some benefits to college athletes, and that was kind of the start. And you saw schools providing what they would refer to as Alston funds to students, and then eventually that also turned into allowing name, image, and likeness to be compensated to the student athletes. And based on the House case, we will now see, as of July 2025, if final approval is given, that the schools will actually provide revenue sharing to the student athletes.
Okay. So what is this House case? You mentioned there was a hearing on Monday on it. Can you give me a little bit of background?
Yeah, so the House settlement is a term that we just kind of collectively use for three cases that we kind of bunched together. But the settlement is between the NCAA and the plaintiffs in the case, and the Power Five conference schools have also agreed to it as well. But the settlement itself is about $2.8 billion worth of compensation back to these students in the form of a couple different things. There's a back pay element, which the timeline for that has come and gone at this point, but students were able to opt in to this back pay to obtain a back pay amount if they were prior student athletes and they weren't compensated in the past. And I want to say roughly 90,000 college athletes opted into that.
Oh, wow.
Just a little below. Yep. Yep. So there was a ton.
And
So not a small number here.
Right. And not to cut you off, Charlie, but for our listeners, that time frame for that back pay was from 2016 to 2024. And where they arrived at that was based on what would have been what they calculated as a statute of limitations for claims that could have been made related to this against the NCAA and the
Okay.
member schools.
Yeah, that makes sense.
So the second portion of it, second big portion of the settlement is a benefits portion that essentially offers student athletes benefits that they haven't been able to get in the past, right? So the additional benefits now we're seeing medical and mental health resources, nutrition resources, life skills development, and even extended medical coverage once the students are no longer playing in college, once their college career is over. So those are a couple things, a couple of the more minor things on the settlement that they're introducing, but the big one is the new revenue sharing model that they're rolling out. So this revenue sharing model essentially allows the Power Five conference schools to share about 22% of their athletics revenue with students directly in the form of NIL payments. So that'll be anywhere from $19 to $25 million a year that schools are able to now directly pay to their student athletes for their NIL. And the big debates are how that money is going to end up being allocated between different sports. Obviously, there's revenue and non-revenue sports. Revenue sports being football and basketball for most schools. Those are sports that bring in the most revenue based on viewership, ticket sales, etc. And then there's the non-revenue sports, which are kind of the smaller sports that are almost club sports, swimming, tennis, stuff like that, baseball. So it's going to be really interesting to see how schools decide to allocate those funds as well. But the revenue sharing model is the big talk of this settlement.
Okay. Are there any other key takeaways from that hearing, or is any updates onto the status beyond what you've already discussed?
Yeah, so as the hearing, I think was what, 8 hours on Monday, Charlie, something like that.
I sat
I
through
think
the whole thing. Sat through the whole thing just for not much to come out of it.
right. Yeah, there were a number of objectors to the settlement that Judge Wilkin allowed to basically present oral argument. And she didn't make a final ruling from the bench, but my takeaway, and Charlie can add his as well. Mine was she really didn't want to change the settlement a whole lot. She'd already given preliminary approval to the settlement agreement, and because of this, and because recruiting never stops, these Division I schools that were planning to opt into the settlement agreement have already started to plan for this allocation.
Okay.
So, take Michigan State, since, we're right here, they've got to make a determination of, okay, if we have, say, $22 million that's going to go towards revenue sharing, what portion of that's going to football, what's going to basketball, and to all of those other sports,
Yeah.
in order for those coaches and their staffs to make a determination of what they're going to do. So Judge Wilkin had given a preliminary approval. This was a hearing that would have been for final approval and to hear from objectors, which she did. And like I said, there wasn't a sense that she wanted to make any wholesale changes. One of the objections that she seemed to agree that there may need to be a change was as to roster limits that were put in place as part of the settlement. What the settlement did was, for each sport, it created roster limits, but unlimited scholarships for those roster spots. So, if you take, say, baseball, and if it's, I can't remember exactly, but I think it's like 34. It used to be a NCAA Division I baseball team would have just under 12 scholarships. Well, now they have a roster limit, but they can give full scholarships to all of those roster spots. In reality, that's not going to happen because the school doesn't have the revenue to do that. And the two sports that pay the bills are football and basketball. So as part of the objections, there were future student athletes or athletes that will possibly lose their roster spots because of the cap. So Judge Wilkins seemed to indicate a willingness or looking for the NCAA and the plaintiffs' attorneys to come to some kind of resolution that would maybe have the roster limits be phased in over a number of years. And that was one part of it. And the second part of it related to the valuation. And I think this was more related to the back pay portion of it. One of the athletes that spoke was, I believe her name is Olivia Dunn from LSU. She's a gymnast that has a very high social media following and has quite a few brand deals. If you look at the back pay allocation and how they did that, which was based on an expert witness, her argument was the allocation was for the NIL, the name, image, and likeness, was way off. And so Judge Wilkin did indicate that maybe the settlement need to take a little closer look at that. So there were really the two things. I don't know, Charlie, if you saw anything or heard anything else that you thought.
Yeah, the other thing that she was hesitant to approve was how the settlement's going to affect future student athletes. So athletes that are in high school still, middle school, that are going to be affected by this 10 years, 20 years down the road.
Mm-hmm.
She was hesitant to allow the settlement to go on without addressing the fact that those student athletes haven't been able to opt in or opt out of this settlement. So she was concerned about how they might be affected and how their rights might be affected later on.
Yeah.
Yeah, maybe we should back up a little bit. We keep talking about opting in or opting out. So our listeners understand these are class actions. So if you're a member of the class, you'll get notification in some way, hopefully, whether that's posting on online or sending emails or whatever it may be.
Yeah,
and
those postcards that you get in your mail that says, your rights may be affected by XYZ kind of thing.
Exactly. And probably everyone here has had some kind of notification that they were part of some kind of class settlement. And if you don't opt out of that, then whatever the settlement is, you're part of the settlement.
Mm-hmm.
And so that's what we're talking about there.
You're releasing your right to sue on your own
independently. Yeah. Okay.
Yeah. So she was concerned that future student athletes wouldn't have that option of opting out and suing on their own behalf.
Yeah. Right. And as part of the class action, the representatives of the class, so that the plaintiffs themselves have to meet a standard so they're satisfactorily representing all parties. So one of those things would be non-revenue sports. Are they representing non-revenue sports? Are they representing revenue sports? Are they representing future athletes? Well, that's a tough one because to add a middle schooler to the class that you don't know if they're going to be a big time recruit or a recruit at all. I mean, that's a difficult thing to do. So that was one of the issues.
Okay. Yeah, and it sounds like, this settlement is really, really multifaceted, right? You have the division of the athletes, you have the division based on the sports, you have the division based on the type of revenue that's out there or the potential for revenue out there. It sounds like an extremely complicated type of settlement that's out there. So with all of these different facets, right, how does it impact name, image, and likeness?
Well, interestingly, I think most people have heard of NIL collectives that have began, paying university athletes, which we've seen, from the major programs, because that's allowed now. And the reality is, after this settlement, if it receives final approval, which I think we're too far down the road, and I think it will get approved, there may be some small tweaks, but I think it will. But the interesting thing is, I think you're going to see a lot of the collectives go away, and most of the money will flow through the revenue share from the universities themselves. Now, one of the arguments that you'll hear in talking to some of the member schools that do opt in is the workaround that is that some schools will hit the cap of, whatever that is that particular year, and then they'll use NIL to pay players in addition to that. And so what the settlement sets up is a clearinghouse that Deloitte, which is a fine, the big
Yep.
financial, CPA auditor firm that will act as a clearinghouse. So if an athlete has an NIL deal, it has to be approved. So, as opposed to if you're signing an autograph, that's probably not worth $100,000. It has to be a legitimate deal. If Nike comes and asks an athlete to, wear their shoe or, whatever it may be, it has to have a true commercial purpose, and
Yeah.
they'll act as what will be the arbiter. And then there's a mechanism to appeal if, those are not approved.
Okay.
More than $600. I think, Dave, is that the cutoff that the deal's worth?
Right. That's the threshold right now is $600, which, I mean, the mechanics of that, I think, for schools is going to be somewhat problematic, and they're not going to want to have to go through that. So the easier way is to have the money flow through revenue sharing. But if they want to go above and beyond that, that's the mechanism to do that.
Okay. And when you say the $600, is that so basically there's no oversight, for lack of a better term? I know I'm kind of paraphrasing here, but in order to be put into the category, it has to be $600. So if it's $599, it doesn't actually apply. Is that kind of how it's set up?
Well, I mean, there's no mechanism to review it, right? So if, Rob Hamor LLC wants to give, an athlete $599, no one's going to review that.
Yeah.
And
Okay.
it's their opinion that amount's so de minimis, it's not
Yeah.
worth the administrative hassle to do that. And how they came up with that $600, I'm not quite sure, but
Yeah.
that's what it is.
Well, being the contract guy, right? I look at that and think to myself, is it in one or in a series of transactions, right? Do I pay 500 athletes, $599 just to keep under in order to avoid doing anything? So it's even with the settlement, it'll be really interesting to kind of see what the future holds, and really that segues into my next question, which is, what does the future hold for college sports? What does it look like, based on the new rulings? And obviously, if you had a crystal ball, we'd be sitting on a beach in Bora Bora somewhere. But what's your best guess as to how the future of college sports looks like under these rulings?
Yeah, Rob. I mean, the quote you'll hear anywhere that you listen to people talking about this topic is that nobody knows what's going to happen, right? And if somebody tells you they do know what's going to happen, then they're lying to you. And we're no exception to that for sure. It's going to be really interesting to see how it plays out, how schools approach it. But one thing we do think will happen is that college sports are going to become more and more privatized, right? So these student athletes, they're going to be acting more and more like employees. That's going to open up conversations of whether they should be employees of the school. So that's kind of the main issue we see coming into play.
But
Okay.
and I would add to that, I think certainly what we're going to have for a while is going to be uncertainty, because regardless of what Judge Wilkin ultimately does with the settlement, there's going to be appeals and there will be other lawsuits. And I know different Congress folks have, thrown out proposals, but I mean, who's knows whether anything actually gets through Congress or not. But so if this settlement is, the way forward, I think what you're going to see is, at least for football, basketball, women's basketball, and maybe some other sports like hockey and some sports at particular schools, they're going to act almost as a pro sport. I mean, especially when you look at the Power 5 football, you're talking about, of this $22.5 million. I talked to a GM at a major school yesterday, and their allocation for football for this year will be $15 million. So that's a payroll that they will have, and they'll be acting, and that's what they have now, is they have GMs. So it's kind of like a pro sport. And what that also does is, they start recruiting high school kids quite early. And 10 years ago, a high school kid was looking at, okay, what are my scholarship options, and
Mhm.
what are the athletic facilities like at this university. Now, if you're a high level football, basketball, player, you're looking at, okay, what does my revenue share look like? And
Yeah.
then, the other part we haven't talked about is transfer restrictions have gone away since COVID. So what these deals are going to end up looking like, in my opinion, is you're going to have 1 year, uh, basically free agency. So, the contract between the member school and the student athlete will be for 1 year. Transfer portal opens. At that time, if they enter the transfer portal, they can renegotiate with any school they want. So you'll see a lot of student athletes that will play for 4, possibly 5 universities over the course of their career if they stay.
Yeah. Well, and it brings up an interesting point, and it's could be more of a philosophical discussion than a legal one here, right? But at what point in time do we prioritize the NIL compensation versus the quality of education, right? And that's going to be a really difficult decision, and especially combined with the fact that it's a lifelong affected decision made at a relatively young age, right? Where you go to school can open doors for you, right? If you decide to go professional afterwards, maybe it's not as important from the academic side, right? But what percentage of college athletes wind up going professional post graduation versus the ones that rely on their degree, right? And is someone going to be incentivized to go to a school with a let's say a suboptimal degree or future career paths because they have a huge compensation package, for lack of a better term, versus kind of taking a look at it from the education standpoint, which and again, this is really a philosophical discussion, right? Are you going to college for the compensation, or are you going to college for the education, right? And there's no right answer. I think it depends on each person. So that comment kind of segues me into the last thing I wanted to talk about, which is what is the advice to the high school recruits and their families, right? We have a dramatic shift in the industry. I mean, this is brand new, watershed moment for NIL and student athletes that are coming up there, and a lot of things need to be balanced, I guess, especially in an era of uncertainty, as you say, appeals going on and things like that. So, what's the advice to the high school recruits and their families? How can they best protect themselves, and to use a sports analogy, also play some offense here?
Yeah, I can speak to that a little bit. I think the big thing is going to be, to ask the questions, to talk to somebody, because this is like really everybody's having a hard time navigating at this point, and doing it on your own as a high schooler or parents of a high schooler is going to make the already stressful experience of putting an athlete into college even more stressful. So,
Mm-hmm.
to make the obvious plug of Foster Swift Sports, we think it's super important that you talk to, an attorney like Dave or myself, or any of the other attorneys that we have in our Foster Swift Sports group, that can help, navigate these deals. We can communicate with schools. Like I know Dave has experience in this area, communicating with schools um, on the value of athletes that are shopping around for where they're going to go to school. We can look at the contracts, um, and just make sure everything's fair for the recruit.
Yeah. It's almost like a true agency, like a true management agency issue that you run into in professional sports, right? And unfortunately, you don't know what you don't know, right? Negotiating one versus negotiating 100 certainly gives you better insight into the process, what's out there, what's reasonable, and also might give you some insight into what the other alternatives are. And I think that experience is probably something that people want to look into. Now, with the short time we have left, I haven't seen any questions kind of pop up in the chat here, and I'm sure that there's some other things that we want to talk about with respect to name, image, and likeness, in the last 5 minutes that we have here. So, are there, and you mentioned before that, there's going to be, some appeal, some litigation, things like that. Where are we seeing people push back on, right? And you talked about it a little bit already, right? What sports gets, what cut of the pie, right? Does gymnastics, was gymnastics fairly treated versus football versus archery versus, curling or whatever sports out there that may take advantage of it? Where do you think you'll see, some of the challenges coming up in the future with respect to this decision?
So I think there's a number of challenges that will be brought up. Title IX requires that the institutions, for at least educational benefits, treat female and male students the same. Now,
Mhm.
these allocations of this revenue share will not be equal. So that'll be one avenue where you're going to see some litigation, I suspect. The other part of it is, are these athletes employees?
Mhm.
And there's been some litigation related to that, but there hasn't been anything that's been finalized on that. So I think those are two of the main issues that we're going to see are related to that. And I think you're going to continue to see litigation related, because what we have here is we still have a cap. And you have a approximately $22.5 million cap there was not a collective bargaining agreement for that cap.
Mhm.
So, for all those antitrust violation attorneys out there, there's a lawsuit to be had,
Yeah.
and obviously they'll point to this settlement as binding, but that's not going to prevent future litigation. So until we get to a point where maybe there is collective bargaining or Congress does pass something, you're going to see a lot of litigation. And I think Charlie's right. You need to reach out to someone that understands it. And and really it's a business attorney to look at
Yeah.
what you're entering into, and not just that, but you probably, if you're a high level recruit, you want a financial advisor, you want someone to look at the tax issue. You have kids coming out of high school that will make more money in their 4 years in high school than they may ever in their entire
Yeah.
career. We're talking $500,000 a year,
Mhm.
and they have to make some decisions entering into those agreements starting their junior year of high school. So,
Yeah.
there's a lot to navigate there, and to have someone to look at, what you're entering into, I think makes a lot of sense.
Yeah. Well, and look, you run into that same issue, with lotto winners, right? And especially when you're dealing with high school students. What high school student wouldn't want a Ferrari instead of, putting the money in the market, right? That may grow, or buying a house, or you're doing some of the more financially prudent, items that are out there. And I don't know what the exact statistic is. I'm probably completely off on it, but I do know a significant number of lottery winners are in the same exact financial scenario they were in before they won the lotto within 5-10 years, right? They don't know how to manage that quantity of money, right? They don't know how to protect themselves on the legal side, on the financial side. They have families coming to them for loans, and all of those sorts of things that are out there. And I have to believe a lot of those lessons really play into what we're dealing with here, right? Some of them are legal issues, some of them are financial issues. But setting things up like trusts may be, an appropriate vehicle to consider. Having someone make those financial decisions for someone that isn't, impacted, right? Someone can be the bad guy. I hate to say it that way, right? Sometimes, right? To say no, because it's real hard to say no when your friends and family are knocking on your door looking for money, right?
Well, and
These
that
are
and that's exactly it. You see it with pro athletes, and you're going to see it with college athletes. No, you all of a sudden you start making all that money. You have a lot of new friends.
Yeah. And the one thing that unfortunately we don't get with college athletes versus pro sometimes, right, is age and maturity, right? I think that, when you're in college, is sometimes an era of bad financial decisions, right? Adulthood can be as well, right?
Sure.
But it's like the 500-hour rule for pilots, right? You know enough to think you know everything, but you don't know enough to avoid doing something stupid, right? I think you run into that issue. So having those advisors, I think, is something that really, really needs to be driven home. These aren't just rote contracts and rote decisions that are made. They're all negotiable.
Right.
Yeah.
So
Yeah, Rob, and that's where we kind of see ourselves as a little different than just a straight up agency. Like, yeah, we can do the negotiations, we can look at value at various schools, but we also, since we're a full service law firm, we've got the tax side of things, we've got the nonprofit side of things, we've got, the trust and estates side as well. So we think we're kind of a one-stop shop for student athletes, both while they're coming out of high school, playing through college, and then even after college.
yeah. Perfect. Well, gentlemen, I want to thank you so much for taking the time to speak with us today. This is a certainly a new topic. It's developing. I know that we have a new practice group formed for it, and I think that some of the information was posted in the chat with respect to some podcasts and some website links. So if anyone's interested in it, we do encourage you to follow our website and some of the media that's being created on this topic. Again, I want to remind everyone we have our next session May 14th, 2025. Please look for your emails for more information to follow on the topic. And again, David, Charlie, I wanted you to thank you both again for taking the time to speak with us today.
Thanks, Rob. Appreciate it.
For having us.
All right. Yep. Take care, everyone. Have a fantastic day.